Let's look at some of the wordings. Now, let's look at this word damage and damages. They're very different words. Okay, just adding the S makes it a very different word. If you damage something or cause damage to something, you do harm to it. You harm it. So, when driving, you negligently scrape Bill's car. This word scrape. Gratto in Italian, I think. You scrape Bill's car and damage it, or you cause damage. When Bill sees the damage to this car, he is angry, and he instructs his lawyer to commence proceedings against you. Yes, he saw you. Case 2, A, B, and C are in the wood business. A and B enter into a cartel, which is an agreement to set prices. A cartel, and damage C's business. So, in both cases, the injured party, so that's Bill in case 1, and C in case 2, can sue the person or persons who caused the damage for damages, which means compensation for the loss suffered. The cause of action in case 1 is the tort of negligence, and in case 2, it's under competition law. But damages, very different. Sound very similar, there's just one letter difference. Damages means compensation, damage means harm. Okay, so damage a computer system and to corrupt a child. To corrupt is the verb, the noun is corruption. There's an organization called Transparency International. It's a non-governmental organization, and it claims to lead the fight against corruption. Now, its definition of corruption is the abuse of entrusted power for private gain. And words that you often hear together in a pair are bribery and corruption. Bribery are illegal payments to people in authority, to government or other organizations. You have things called facilitation payments for something that the bribe receiver is required to do by law. So, okay, you work for the government or a public authority, it is your job to do something. But you say, okay, you want that? Well, come on, where's the envelope? Where's the brown envelope? And we talk about these kind of payments being made in a brown envelope. I don't know why. Or payments under the table. Okay? And we have an act, a fairly recent act. The United States has had this legislation for a long time, over 30 years, in which we try and make it a criminal offence for British companies to be involved in bribery and corruption overseas. So that's what I mean by extraterritoriality. Yeah, it means that crime occurs outside the territory of the United Kingdom. Corruption, I think, is wider than and includes bribery. Examples of favoritism and nepotism. And, where did we get onto this word? Because we were talking about corrupting a computer system, corrupting a virus. You also corrupt children when you tell them, when you tell children about what grown-ups get up to, particularly sex, when they're too young to know about it. That's corrupting a child. We also saw the expression a provincial firm. Literally, it is a firm which is in the provinces, so it's not in the capital city. But also, the people in the capital city will say, oh, it's a provincial firm. They sort of look down on it. There is that meaning as well. They use the word firm correctly, because it is a partnership is a firm. But this word firm will often be used incorrectly, even by people whom you would imagine would know a lot better, such as the Financial Times often talks about firms when they're not talking about partnerships, they're talking about companies. And businessmen will often talk about firms when they mean companies. Implied by law, as Sarah will tell you shortly, in a contract you have two types of term. You have express terms, they are written down there, and you have implied terms. And an example of an implied term is given here under Section 14 of the Sale of Goods Act. The following terms were implied by law into into the contract. That the goods were of satisfactory quality and they were reasonably fit for their intended purpose. So every time you go into a shop and buy something, those terms are implied into the contract. I'm sure you have something very similar under your commercial code or civil code. Full particulars of the loss and damage will follow in due course, however, without prejudice to such particulars. The aim of damages is to compensate the injured party for the loss and damage he has suffered. Okay? It is not punitive like it is in some parts of the United States. Without prejudice means without taking away from. And we have something called, in litigation, a without prejudice letter. And I'm not sure you have these. I'll tell you what they are, without prejudice letter. It means, let's say X has sued Y for 100. In an attempt to settle before the case starts, Y offers 60 without prejudice and without admitting liability. And because the offer is made on a without prejudice basis, if and when the matter proceeds to trial, X cannot say, well, look, he's offered me 60 already. He must be liable. Yeah? That's the point of a without prejudice offer. If the other party does not accept it, you cannot talk about it. That other party cannot disclose it in the trial. Let's move on. Let's move on. We've seen the claim form. Next, please, the defense and counterclaim. Let's have a look at that. Right. There's a lot of small writing on the first page. Some of it is pretty important, and I'll just read out a little bit here. It says, in your defense, you must state which allegations in the particulars of claim you deny and your reasons for doing so. If you fail to deny an allegation, it may be taken that you admit it. Okay, so remember the context. We've seen the claim form. This is the defense and counterclaim, or not. Yeah, perhaps there's a counterclaim, perhaps there isn't. But let's think of this as the defense. These are the instructions on how to complete the defense. So, if you fail to deny an allegation, it may be taken that you admit it. Now let's look at these two key words here. To deny. To say that something is not true, or that you do not believe something. The noun is denial. You deny that. The accused denied that he was at the crime scene. And then to deny doing something, the witness denied being at. It means the same thing, it's just a different construction. To allege is to say that something is true or that someone has done something wrong, although it has not been proved. So it is the noun is an allegation. If you look at any newspaper report of a criminal case, you will see the word allegation and alleged all the time, because until the accused has been found guilty, it is just alleged that he committed the crime. Okay, we'll look at that a bit more tomorrow. Okay, let's read, please, the defense and counterclaim. the defense, okay? Starting here, the defense. So, I'll start. Paragraph 1 of the particulars of claim is admitted, okay? Paragraph 2, admitted. Paragraph 3, admitted. Wow, the claimant's doing really well. But then look what paragraph 1, 2, and 3 say. So, you know, all they have admitted is, yeah, some basic questions of fact, okay? But useful, but it's not, they haven't really admitted anything that goes to the heart of the claim. So, sir, can you read, paragraph 4 for me, please?
The first sentence of paragraph 4 of the particulars of claim is admitted. With regard to the second sentence of paragraph 4, A, the defendant is unable to admit or deny whether the claimant's computer network has been damaged, whether a virus or otherwise. The claimant is put to proof of this allegation. B, to the extent that it is proved that the claimant's computer network has been damaged, the defendant denies that this is the result of any virus introduced by the software supplied to the claimant under the contract.
Okay, thanks. Damaged, not damaged. Damaged. Okay, thank you. Can somebody do this side? Can somebody read? Gentleman, yeah, with the beard.
With regard to paragraph 5 of the particular complaint, A, to the extent that is
Proved.
proved that the claimant's accounting system has been damaged, the defendant is unable to admit or deny whether any such damage has affected the claimant's ability to recover outstanding fees. The claimant is put to proof of this allegation. B, the defendant is unable to admit or deny whether the claimant has lost any existing or future business since 17 January 1999. The claimant is put to proof of any such loss. C, insofar as the claimant has suffered any loss of business since 17 January 1999, the defendant denies that this was caused by damage to and/or corruption of its computer network. Further, the defendant said that insofar as the claimant has suffered any loss of business since January 1999, this is wholly or mainly attributable to adverse publicity arising from the arrest of the claimant's senior partner, Mr. John Counter, on charges of defrauding the claimant's clients. This occurred in 14 January 1999.
Wow, that's a bit of a twist at the end there. Defrauding. So, he's been arrested. Wow. Okay, let's look at some of that wording we use there. The claimant is put to proof of this allegation. All that means is prove it. Prove it. And how do you prove it? With evidence, and the evidence can be oral or written. It said, to the extent that it is proved that the claimant's computer network has been damaged, the defendant denies that this is the result of any virus. So, to the extent that, it could be anything between 0 and 100. Yeah? So what the defendant is saying, no, it's not damaged. It's not damaged. Your computer system, computer network hasn't been damaged. You haven't proved it. If you want me to listen to this claim, prove that it's been damaged. That's what this is saying. So, I said, we're coming to the end now, time for coffee. I said we were going to look at 3 things. The courts, sorry, did I miss? No. I said we were going to look at 3 things. The courts, a claim form and defense, and the rules of civil procedure. We've looked at the first 2 things very quickly, the rules of civil procedure. I did not specialize in litigation when I was practicing as a lawyer. And so it's only fairly recently that I have looked at the rules of civil procedure. And I'm impressed by them. They're very thorough, they're very well written, and they're written in quite simple, straightforward English. So my advice to you is that they are a good starting point for you in your studies of the language of litigation. First, look at the table of contents to see what they cover. They cover a lot. And then, you know, there are things like evidence, in this case, interim remedies, which means remedies before the final judgment has been given. Now, if you have to give advice in English on these topics, yeah, you don't need to know the English law, but these are useful places for you to find the English vocabulary. There's also a glossary, which is very useful. A glossary is a set of defined terms. They define some of the most commonly used terms. So as I say, let this be your guide when you have to advise on litigation in English. There's something called practice directions. These are mainly administrative. Don't worry about those. They're things like, you know, what time the court's open, what administrative things. Pre-action protocols. These were introduced by Wolf to encourage early settlement. And just one of the protocols, this will give you an example, one of the protocols. The main aims of personal injury pre-action protocols are, you can see the 5 bullet points there. I'm not going to read them out. It's time for coffee. Thank you very much. Thank you.